Guzman. Could I have parties announced for the record for the state?
Jason Jorgens for the state.
Defense?
Robert Maurer for defendant, Your Honor.
And are you Mr. Guzman? All right, the first thing, the corpus seeking release because of delay. State, have you had a chance to review both motions?
Yes, Your Honor. And just to be clear, the motion for speedy trial, was that dated back in September of last year? That's the most.
No, one was another one was e-filed, but it wasn't e-filed till yesterday, unfortunately. So it just came through. If I got my copy, you can have my copy. Here you go.
Okay, Judge, we're ready.
All right, so we'll proceed first with the motion for speedy trial. Defense, it's your motion. Everyone in the box, excuse me, in the box, I mean, we're going to need you to move down to the end or whisper. Oh, no problem. All right, defense, it's your motion.
Judge, we filed a speedy trial motion on this case due to what I feel is excessive delay. My client's been incarcerated since 2019. This previous Tuesday was the 14th trial setting. There's been no motions for continuance filed by the defense ever on this case. I pulled the record of all the settings. The only motion for continuance was filed by the state back in, well, there was one in 2021, was a state's motion for continuance based upon discovery issues. And the discovery issue, if the court recalls, was an issue about the state saying that there was cell phone mapping data that had been sent off to the FBI that my expert needed to review in order to make a determination whether or not the evidence the state was alleging about location tracking was valid. So unfortunately, it turned out that we came back in 2022, and this is, I think, the September 27th, 2022, and Ryan Grimmer, who was the first chair at that time, informed myself and the court that, in fact, the cell phone mapping data had not been sent off, and there was an agreement that there would be no attempt to use any cell phone mapping or tracking evidence. So there was over a year's worth of delay while we were waiting for evidence that had never been submitted to the FBI and is not being made part of the trial. So my client, of course, we had a previous speedy trial motion. We had requested bond reduction before, and I understand the court's concern about the nature of the offense.
Well, with regards to the bond reduction, we'll address that in
I understand. My entire point is the cause for the delay on this case has not been the defense. The cause for the delay on this case for over a year was the state not providing evidence and then turning out the evidence was not actually submitted. And so my client is, and I understand the issues with COVID, and we all dealt with the Zoom hearings and things like that. But even after COVID, we've had delay based upon evidence that was not submitted or evidence that was not, I wouldn't say turned over, because it turned out the state didn't have the evidence either and was never requested. So my client suffered through an extra year of incarceration based upon procedural issues with the DA's office. And it's unfair to him that he should be stuck sitting in jail all this time based upon issues with discovery within the DA's office. Like I said, this is a 14th trial setting when we were here on Tuesday. The defense, other than when we were waiting for the discovery, has been ready. And I've been ready on every other setting. But every time we show up, another case goes. Even cases like this week, the case that went to trial was a defendant who had half the time of incarceration that my client did. I announced ready for trial, and I have been ready for trial other than waiting for the FBI mapping data ever since. So I'd ask the court to dismiss the case based upon lack of speedy trial. I don't think the way that my client has been treated procedurally is fair to him. He's been incarcerated for almost 4 years, and I think the case should be dismissed or called to trial right away.
All right, State.
Your Honor, For the court's consideration, I have the case of Dragoo versus State. It's 96 Southwest 3rd, 308. I've previously tendered a copy of this case to the defense. In that case, Your Honor, there was a similar delay of about 3.5 years. And that the court in that case analyzed the normal Barker factors in considering the motion to dismiss for lack of speedy trial. With regards to the first Barker factor, the length of the delay, obviously there has been more than the presumptive 8-month window for this case. So because of that, we're moving on to the remaining 3 factors in the analysis. For the reason for the delay, Judge, the second Barker factor, the mere passage of time under United States versus Spoonhunter, the mere passage of time itself does not constitute a denial of the right to a speedy trial. In this case, and most significantly, there was no...
Guzman is facing multiple felony cases and has already spent years in custody. Now the defense is asking a critical question: who is responsible for this lengthy delay? And could that delay amount to a violation of his right to a speedy trial?
Bad faith or no intention by the state to deny the defendant his right to a speedy trial. The state has only requested, in the entire duration of this case, the state has requested one continuance, as opposing counsel mentioned, for a discovery issue that came up. And also, as opposing counsel mentioned, there was a pandemic, right? We have a once-in-a-lifetime event that occurred during the pendency of this case, during which time the courts and the courthouse were shut down for going on a year, close to 2 years at some point, during which time a trial just would not have been possible because there were no jurors being brought in to take your cases. In regards to the third Barker factor, the assertion of the right to a speedy trial, the defense, as far as I can tell from the record, first moved for a right to I believe the arrest in this case was July 29th of 2019. I believe the first assertion of a speedy trial was in June 11th of 2021. And of course, that was during the middle of the pandemic where a speedy trial could not have been granted because jurors were not being brought into the courthouse. With regards to the I don't believe defense has articulated any specific prejudice other than the length of the delay in this case. But at the very least, that would weigh against the defendant for not articulating particularized prejudice. We believe that the assertion of the right to a speedy trial also weighs against the defendant because he did wait so long before first asserting his right, and also his lack of persistence in asserting his right to a speedy trial. The next assertion of his right, I believe, was about a little less than a year after his first assertion. And in Dragoo, the court did note that, sorry, I don't know, let's find it. Did indicate that the lack of a timely demand for a speedy trial indicates that he did not really want a speedy trial, and also furthermore that he was not prejudiced by the lack of one. The inaction of the defense weighs against the delay being a violation of a right to a speedy trial. To distinguish Dragoo from this case, Your Honor, in Dragoo, there was no reason offered by the state for the delay, which the court held does not indicate or does not significantly weigh against the state. In this case, we do have a reason for the delay, Your Honor. Again, we had a 2-year pandemic that essentially backlogged the entire system. So we have a reason for the delay, which I believe would indicate that factor should not weigh for or against either party. As a result, and just to address defense counsel's last point, I don't believe he raised in this motion, but in moving to dismiss the case for lack of speedy trial, there is case law that indicates that an assertion that a case should be dismissed weighs less heavily against the state in that the defendant does not actually seem to want a speedy trial. He seems to want his case dismissed. So for those reasons, Your Honor, we're asking the court to deny the motion and to deny the motion to dismiss for lack of a speedy trial.
May I respond?
Yes.
So, Judge, as far as the issue about assertion of a right to speedy trial, we did it during the middle of the pandemic. Then, if I'd like the court to take notice of the state's motion for continuance that was filed for discovery issues, and that was when the issue was raised about cell phone mapping data.
And
it had not been turned over to me. That was back in
June 14th, 2021.
That was my motion. That was my speedy trial motion, correct?
No, that was the state's motion for continuance.
Yeah, okay, that's correct. And then September 27th of 2022, we had a hearing in which Mr. Groomer informed the court and informed myself that in fact the cell phone mapping data had never been sent off to the FBI. So the evidence that I had been waiting on, that I was supposed to rely on for my trial, that I had an expert prepared to review, never existed in the first place. So if the court looks at the timeline, we're talking about 13 months roughly where we were waiting for data that the state said they had, that they were going to get to me, that never existed. And of course, had we known that at the time, we could have tried the case back then. As far as any sort of harm to my client, I apologize for not articulating the fact that he's been in jail for now 1,292 days. I think that would articulate his harm. The fact that he's been held in jail all this time, particularly when over a year of that delay is based upon error in the DA's office as far as evidence that was supposed to be turned over. So, and if the state's argument is, during the pandemic, I understand that, but subsequent to the pandemic, when the courts opened back up, we had a large period of delay waiting for evidence that the state said they had, that they were going to get to me, that never existed. And then I've been ready for trial every single time since then. I'm ready for trial now. I was ready for trial on Tuesday. The entire issue is we keep coming to court for trial, and other cases keep going, even cases that are not as old as my client. So there's no attempt to avoid trial. I've been ready. But I think based upon the undue delay, my client's entitled to a dismissal.
And Judge, if I could very briefly respond, because you brought up a point that is actually covered by Dragoo.
Yes.
In Dragoo, the defendant failed to assert he claims that he failed to assert his right to a speedy trial because he was waiting on a dismissal by the state. Essentially, the state had apparently promised to dismiss the case at issue in Dragoo if there was a final conviction in a separate case that the defendant was charged with. And they're asserting that was the reason for the lack of assertion of the speedy trial right. We've got a similar situation here in which the defense is saying that they're not asserting the right to a speedy trial because they were waiting on discovery. The court did not find that persuasive in Dragoo. So the reliance, if there was any, was in the court's view, the appellant quietly acquiescing to the delay.
Judge, I'd like to respond to that.
Just 1 second. Isn't it slightly different than the defense waiting for a dismissal as opposed to the defense that's waiting for discovery that may or may not be exculpatory?
Sure. Yes, it is different, Judge. I was just pointing out that it was analogous if they're waiting on something from the state. They still have an obligation to assert the right to a speedy trial if that's what they're seeking.
But they were waiting on discovery, my understanding, and I remember distinctly, they were waiting on discovery from the FBI with regards to some sort of GPS mapping. And I remember, I think the waiting or the request for discovery started with ADA Nesbitt.
Correct.
And then it went to ADA Groomer.
Correct.
The defense argues that Guzman has spent nearly 4 years behind bars with more than a year of delay allegedly caused by evidence that never actually existed. Now the court has to decide whether that delay was legally justified or whether it unfairly affected the defendant.
And counsel, just to address your issue of other cases going before him, some of the cases that went to jury trial before him was because they were already set for trial because we were waiting on this mapping thing. And Mr. Guzman, I want you to understand when there are other cases that may not be as old as yours and they're going before you, it's because everybody knew that they were set on this specific date. So some of them already had their setting while we were waiting on this FBI mapping.
If I can respond. So subsequent to us being informed back in September of last year that there in fact was no cell phone mapping data, we've had several settings we've been ready on. And to say waiting on a dismissal is the same thing as saying waiting on evidence that may be exculpatory, I think is a nonsensical argument. I can't proceed on a case if I'm told there is cell phone mapping data that the state intends to rely upon at trial that may prove could prove exculpatory, then of course I've got to wait for it. I've got to see what's there. So that delay took, if you look at the calendar from the time the motion for continuance by the state was filed to the time we had the hearing where Mr. Groomer informed us there was no mapping data, was over a year. So that shouldn't, to say that I should have argued for a speedy trial because the state hadn't provided evidence, I don't think makes any sense and doesn't track to the argument from the Dragon case at all. The state was in control of the evidence. I had to wait for the evidence to make sure that I protected my client's rights. And then once the state informed us there wasn't any evidence, then I was ready for trial. And so the delay or to argue that I should have filed a speedy trial motion while I was waiting for evidence that was potentially exculpatory, I don't think bears any merit.
Okay. All right. So with regards to the motion to dismiss for speedy trial, that will be denied. What I am going to do is place this on the docket, and regardless of whatever is set, this will be the case that will go. So have both parties had a chance to confer on a date?
I think we have dueling dates.
All right. So what date are you requesting defense?
I'm requesting March 20th, or I'm sorry, March 21st, but your dockets are Tuesdays, right?
Yes. And let me see. You're requesting March 21st?
21st.
And State, what are you requesting?
Judge, we're asking for April 3rd. If the court isn't inclined to reset it that far, we'd ask for March 27th.
All right. And I'm assuming the reason why the state is asking for the week of March 27th is because that's Criminal Trial Division's week?
Sorry, Jason.
Yes, Your Honor.
All right. So family violence is the week of the 27th?
And I'm in Lee County on the 28th in district court. That's what I asked to do the 21st.
So we would ask for April 3rd then.
All right.
Friday's Good Friday.
That's true. So here's my question. The week of March 20th, is a murder case already set on that day or something else that's set?
I murder manslaughter.
All right. So a murder is already set for that week. Mr. Maurer.
Is it older than this case?
Yeah.
He's the attorney.
You're trying to see, right?
I want to go.
No. Here's the thing, Mr. Guzman. I don't want to bring you back on March 21st if there's a murder case that is definitely going to go that day. And so all the trials that are set, we have several murders that are set that day. So if we move it to the week of April 3rd, we will definitely be going the week of April 3rd. So
I guess my concern is with Friday being Good Friday.
We can do jury. What we can do is we can do jury selection, and jury selection would happen on April 4th. And then everyone can start their testimony. And then I can have the jury come back that Monday. So the fact that it's Good Friday is not going to be a problem. And when we awarded a jury, we can just see who's going to be out of town, and you all can take that in consideration in selection.
I would still request the earliest court date possible. Just based on the amount of delay on this case.
All right. So, Mr. Maurer, I understand what you're saying, but I'm going to move it to April 3rd will be the day that you all will come in to make sure that if there are any other motions that need to be heard. But Mr. Guzman, your actual jury trial and jury selection will happen on April 4th. And Ms. Ferguson, because that is the week of Good Friday, can you make sure that we've already put our notice in that we're going to need jurors here on April 4th?
Judge, the jurors are going to be downstairs from now on.
Yes.
So we can.
Well, but still, I understand, but make sure that there are jurors there on April 4th. That's what I want to make sure. I understand that they're doing this thing where we can order jurors whenever, but sometimes that doesn't happen. Tell them that the 187th needs a panel on April 4th. I don't want us to not have a panel available to us.
I will contact them right now, Judge.
All right, thank you. So we're going to make sure that we have a panel.
Okay, Judge, the other issue I wanted to raise was bond. My
Yes.
client's been incarcerated.
We're going to get to that. Let's do this first so that everybody know where we are. So you're going to be brought over on April 3rd. On April 3rd, any motions that anyone has that needs to be heard, we'll hear it on that day. Are there any other motions? I'm assuming there's no motion to suppress or anything because those are usually carried with.
The prosecution argues that a lengthy delay alone does not automatically prove a speedy trial violation. The state points to the pandemic, the timing of the defense's requests, and the lack of specific prejudice. So the real battle is over one question: who should be held responsible for the delay?
You won't be brought over dressed for trial on that day. It's just to make sure that everyone has everything that they need. Then you'll need, on April 4th, you'll be brought over dressed for trial. You'll be dressed for trial in whatever clothing, civilian clothing you have at the Bexar County Jail. If it's something else that you'd rather be attired in, you'll need to speak to your attorney and they'll need to do a clothing exchange and you'll have to sign documents for the clothing exchange. Counsel, if there's an issue with clothing exchange, please let us know on April 3rd, make sure that happens. All right, so the next issue we have, and
Sorry, Judge, just for clarification, we're starting testimony on the 5th then, right?
yes,
Okay. Thanks, Judge.
you're welcome. So let me put this on the calendar. So because of all the issues, and I already know that you want a trial, but I'll make April 3rd the plea deadline date and the jury trial date just because of all the issues that we've been having. All right, so then the next issue we need to take up is this bond issue defense has filed. Have you all had a chance to review the application for a writ?
Yes, Your Honor.
All right, State, are you ready to proceed?
Yes, Your Honor.
All right, defense.
Judge, my request is that my client be granted a PR bond. I know it's unusual on these cases, but based upon the extreme amount of length of incarceration, I think it would be appropriate to grant him a PR bond. The court can set full house arrest with GPS. I just think he should be entitled to that. There's been an extensive delay on this case, and I think, in all fairness, I think he should be granted a PR bond.
All right.
If not, I'd ask the court to reduce the bond to the lowest amount possible.
All right, the PR bond will be denied. State and defense, have you all had a chance to discuss with regards to a bond reduction?
I haven't heard, Judge.
I just think that I doubt we'll come to an agreement because
If you all will confer to see if you all can come to an agreement on a bond reduction. If you can't come to an agreement, of course, I will set a bond.
Okay.
But just talk to each other.
Okay, and briefly, what on the hearing we had with Ryan Rumor concerning the cell phone mapping data, the court made an order at that time excluding mention of cell phone location and tracking evidence.
Yes.
So I'd like to see if I can get a copy of that just to make sure it's on the record, so we can raise it on motions in limine or put it on motions in limine at the time of trial.
It should be on the record, but that will be with Brenna DeMoss. And I believe that was something that was requested by the defense because the state had data that was supposedly sent to the FBI. But then my understanding is that no one sent it to the FBI. So there will not be mention of cell phone mapping data because there is no cell phone mapping data.
And Judge, I think the court actually excluded all mentions of any location tracking or anything else because without the mapping data, cell phone location evidence is irrelevant. So that should be part of the hearing, and I think Ryan conceded to that. So I'd like to see if we can get a copy of the transcript just to make sure we're specific as far as what the state conceded to. I don't know how to go about where I'm.
Well, we'll contact Ms. DeMoss, but as far as the courts is concerned, there is no mapping data. Correct, state?
Sure, Judge.
I mean,
As far as I know.
As far as the state's aware, there's no mapping data.
so then there is no pinging of Towers testimony that is going to be before the jury. I think that would be unfair to the defense because they've been waiting for mapping data and none has been forthcoming. But we can, I think the state understands the court's ruling,
Yes,
but counsel, if you still would like to find the, we can get in touch with the former court reporter, Mr. Moss, and find the exact.
I'd like to, just because I think that the specific conversation was it was going to preclude any detectives or any witnesses for the state from mentioning location tracking or location cell phone evidence, because with that, that was the entire issue with that my expert said without mapping data, it's irrelevant. And I don't want, and we talked about not making sure nobody got up there and said, well, we have tracking stuff on cell phones, since in fact, there is no evidence to corroborate it.
All right, state.
Judge, I guess I don't know what the specifics of the agreement were with the prior prosecutors. We don't intend to get into the cell phone mapping data unless the defense somehow opens the door to it.
All right, and no issue that there was any type of tracking?
The only thing I can think of, Judge, and I don't know whether cell phone extraction exists for this case, but if there was a cell phone extraction, the cell phone may have location data of places that he has visited, which wouldn't be a mapping issue. It would have the coordinates that the extractor could testify to.
That's the exact issue that my expert talked about, because without the mapping data, though that evidence is irrelevant. And so that was the entire issue that we raised on that hearing.
All right, this is what we'll do.
But that's not a cell phone.
But this is what we're going to do, because the whole issue of this is what the previous prosecutor agreed to, and based upon that agreement, what the court ordered. So we will get in touch with court reporter DeMoss and have her pull the record on the issue of tracking and mapping data and state if that is what the previous prosecutor agreed to in the court order, then that's what's going to be agreed to in order.
Sure, Judge.
So we'll have her pull that.
All right, thank you, Judge.
Is there anything else? You are going to confirm? Okay, thank you. All right, we're back on the record on Guzman. Defense, what bond amount are you requesting? The court has denied your application or your request for a PR bond.
Judge, I request a $25,000 bond.
All right, state, what are you requesting?
We're requesting the current bond. I think there's currently a $125,000 bond.
Yes.
We're requesting the court to keep that in place in consideration not only of the nature of this offense, but also the fact that Mr. Guzman is charged with, I believe, 6 felony cases from 4 different states, and four of those charges are violent offenses, aggravated assault, or the murder that we're doing today.
All right, and what are those cases and what are the dates?
The cases are 2019 CR 11945, which is an aggravated assault with a deadly weapon from May 26th of 2019. Then 2019 CR 11418, which is an aggravated assault with a deadly weapon from June 24th of 2019. And then from the day of the murder, he is also charged with aggravated assault with a deadly weapon. That's July 29th of 2019 in cause number 2019 CR 10922. And then subsequent to the murder, we had a case of felon in possession of a firearm, as well as possession of a controlled substance, penalty group 1 to 4 grams, from July 30th, 2019, the day after the murder. And that was in cause numbers 2019 CR 11419 and 11420.
All right, and it's your motion, so I'll give you a final.
Judge, I understand the issue with the other cases. I still think based upon the issues we've been dealing with, a $25,000 bond is appropriate with whatever conditions the court feels is appropriate. And I'd ask the court, should have had my office file the same motion on the ag assault out of the same transaction to set the same bond amount.
All right. And which aggravated assault is that?
The last one that Jason read, the one from July 29th, 2019.
And what's it called?
It's 2019 CR 10922.
All right. Any objection to the defense's oral motion to reduce bond on 2019 CR 10922?
Yes, we object to that bond reduction for the same reasons, Judge.
All right. No, do you have any objection to counsel presenting that motion orally?
Oh, no, that's fine.
Okay. But you're rejecting to his oral motion for the same reasons?
Yes, Judge.
Okay.
The defense makes a powerful point if the state said the evidence existed waiting for it before trial was necessary, but the judge is not persuaded and denies the speedy trial motion. The case is not dismissed now the trial is moving forward.
All right. Court will deny the motion for bond reduction. You will be here on April 3rd, and your case will go for jury trial on April 4th.
All right, thank you, Judge.
All right, thank you. CR 007983, the state versus Robert Galvan. Can I have parties announced?
Lauren Espinoza for the state.
Zachary Green for defense.
And are you Mr. Galvan? Counsel, have you received all discovery? Did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Galvan, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Okay, Judge State move to proceed on the lesser included offense of possession of controlled substance, PG1 less than 1 gram.
Any objections?
No objection.
All right. Did you review the court wait a second. I'll wait till they finish talking on the side. Then I'll get back to you. All right. Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
All right. The state is proceeding on the less included offense of possession of a controlled substance penalty group 1, less than 1 gram. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently confident and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Galvan, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
Mhm.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain agreement with your attorney? Did you understand it? According to the plea, the state is proceeding on the less included offense of possession of a controlled substance, penalty group 1, less than 1 gram. They're asking that your punishment be assessed at 180 days in the state jail facility. There's a $600 fine. This is run concurrent with 2026 CC 006816. Did you understand that to be your plea?
Yes, ma'am.
State defense is at the plea.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Any such motions?
No, Your Honor.
Then to the less included offense, how do you plead? Guilty, not guilty, or no contest?
Guilty, ma'am.
State any evidence?
Your Honor, state offer states exhibit 1 and all attached.
No objection.
All right, state, you may be excused.
Thank you.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state will call in the right to remain silent.
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports but most importantly, there'll be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
We would ask if the court could probate the fine. I was appointed to his case, and it'd be hard for him in his current situation to pay it. So that's our only request.
All right, thank you. Court is going to sentence you to 180 days in the state jail facility. Give you credit for any time served. There's a $600 fine. Time and money will run concurrent. This is to run concurrent with 2026 CC 006816. There's to be no residing in households with minors and no unsupervised contact with minors. And I'm doing that based upon the stipulations that are in the report of you hitting a female near a swimming pool area and also the parole violations. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea, because I followed your plea, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, make better choices. Get your life together. Otherwise, you're going to end up in prison for the rest of your life. You understand? All right, good luck to you. Thank you.
Judge.
The defense now takes another shot asking for Guzman to be released on a personal recognizance bond. But the judge denies that request while the state points to multiple felony cases and violent offense allegations. Suddenly, even a bond reduction looks like a long shot. The final ruling is in the speedy trial dismissal is denied, and the bond reduction is denied as well. The court sets April 3rd for proceedings and April 4th for the jury trial. After years of delay, the case is finally moving toward trial.